stops. Are vehicle stops justified based solely on the registered owner? So there's a difference between having reasonable suspicion and probable cause. Reasonable suspicion cannot depend on simply a general suspicion or a hunch. Instead, an officer may have reasonable suspicion only if an officer can point to a specific fact which suggests a crime is being committed. Then we have probable cause. Probable cause may be established by demonstrating that an officer has a reasonable basis for believing that it is necessary to investigate further based on the totality of the circumstances. Then we have a Terry stop. A Terry stop allows an officer to seize or stop a person based on reasonable suspicion. So if before you even have probable cause, if you have reasonable suspicion as a police officer, you can pull somebody over. Probable cause comes after reasonable suspicion. The name Terry stop actually comes from a case between Terry v. Ohio. And this case involved the question of a legal stop and frisk. In this particular case of a Terry stop, Martin Fadden, a Cleveland police detective, conducted a search in an attempt to stop a possible armed robbery. He patted down 3 men who believed were preparing to rob a store. 2 of the men, John Terry and Richard Chilton, were both carrying firearms. They were tried and convicted, although they appealed. The Supreme Court of Ohio affirmed the conviction. This case was argued before the Supreme Court in 1967. So the Supreme Court ruled that McFadden had the authority to conduct, for officer safety, a limited pat-down for weapons because the suspect was observed engaging in suspicious behavior, and this warranted inquiry by the officer. Vehicle checkpoints. So on the other side of having a reason to pull somebody over beyond reasonable suspicion or probable cause, if you have a vehicle checkpoint, everybody's getting pulled over. So there's no reason to have one particular person get pulled over. Everybody's getting pulled over at that point. Everybody's getting stopped. Everybody's getting checked. There could be a DUI checkpoint. It could be just a stopping just to check your license, make sure everyone's valid. But there is such a thing to get around having to do a Terry stop or to have a reasonable suspicion or probable cause, and it is a vehicle checkpoint. So once an officer has reasonable suspicion, so to give you guys an example, if an officer says, okay, well, this person is speeding. Well, once the officer pulls that person over and says, okay, I'm pulling you over because you were speeding, well, you can write that person a ticket, but then after you're done with that ticket, unless there's any other reason to investigate further, you're done with that traffic stop. You do not continue to look for things that could be wrong. The officer may ask, can I search your vehicle, or can I do this or do that? But you have the right to say no if he has no reason to. So when a registered owner of a vehicle has a suspended or a revoked license, a person with a revoked suspended license can own a registered vehicle and lend their vehicle to somebody else. And this is not disobeying the law by any means. Another instance that could happen is someone could get a vehicle, have their license then revoked after that vehicle is registered, and in that instance they may need to go to the DMV to sort that issue out for whatever reason, or pay that fine, or do whatever they need to do. They don't need to get there by a bus. They can have somebody else who is licensed drive their vehicle and bring them to the DMV or wherever they need to go. Driver's license suspensions. So whenever somebody does have a driver's license suspension, the assumption is that they've lost their license because they don't know how to drive or they've disobeyed the law so many times. But in reality, we've seen an explosion of driver's license suspensions for reasons not related to driving at all. They may have not paid child support. They may have not paid a fine or some sort of court cost. This has nothing to do with their ability to drive a vehicle. In this case of Kansas v. Glover, Deputy Mayer randomly ran a tag of a 1995 Chevy pickup and discovered that the vehicle's registered owner was Charles Glover. Charles Glover did not have a valid license. Deputy Mayer had no other reason to pull him over. There was no violations, no traffic violations, nothing of the matter. He was not speeding, he wasn't disobeying any sort of laws. It's just that the registered owner of that vehicle did not have a valid license. So my question is, did Deputy Mayer have reasonable suspicion to stop Mr. Glover? So now there's suspicion of who a driver is, and there's ways to figure out who that driver is and what do you do as a police officer. If you're a police officer and you see somebody pass by you and you run their tag for whatever reason, and you find out that the registered owner of that vehicle does not have a valid license, there's things that you can do. You can see the picture of who that person is. For example, if you see that the person who owns the vehicle is a 37-year-old white man, and you get up to the vehicle and you see that who the driver of that vehicle is somebody who's in their 60s, a female, doesn't match the description by any means, your stop is over with. There's no reason to continue that search. So this is now argued, because how do you find out who that person is without pulling them over? Well, if you, as an officer, pull up next to that person, or if you follow them to see if they do anything else that is illegal, that's pretty much harassment. That does not need to be done. So my argument would be, pull that person over. Once that person is pulled over, and you walk up to the vehicle, if they don't match the description, or if they hand you their ID, and their ID doesn't match who the registered owner of the vehicle is, the stop is done. There's no other reason to continue that search. And this is what is stated in the Fourth Amendment. The Fourth Amendment states, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath of affirmation, and particularly describing the place to be searched, and the person or things to be seized.